The Supreme Court just heard a major case on gun rights, a case coming out of New York. It's New York State Rifle and Pistol Association versus Bruin. And the case looks to be an opportunity for the court, and now a 6-3 court, to ringingly affirm the Second Amendment. Now, the Second Amendment has been under assault, kind of in all the blue states, but particularly up in the Northeast, New York, and up in New England, and also California. And what these states have done is they've basically taken a line from the Supreme Court's earlier Heller decision to say, a line that said in effect that the Second Amendment is, quote, not absolute, and essentially gone to town over that. They've been passing all kinds of restrictions, and now they know that the court is more conservative. So, in fact, there was a New York case in which New York passed a restriction. It was making its way to the Supreme Court. It was likely to be struck down, and New York realized, listen, why don't we pull the law so the Supreme Court doesn't have the opportunity to slap us down? But here, what happens is New York has a law that essentially says that if you want to carry a gun, conceal carry, there's no open carry, so it has to be conceal carry, you have to show special circumstances. You have to show why you, in particular, have, quote, good cause to carry a gun. You've got to essentially plead with the judge. And the plaintiff in this case, a guy named Robert Nash, he's a gun owner. He went to the Rensselaer County, New York judge, and the judge went no. Now, let's remember that these New York and California judges routinely deny applications for gun permits. And it doesn't matter if your circumstances seem you need protection, you received death threats. They just go, no, we don't think that we don't think that justifies. We don't think that meets the standard. And so this kind of rejection of these gun permits is just routine in these states. So in effect, the Second Amendment is nullified. You can technically own a gun, but you can't take it anywhere. So it doesn't offer you any, you may say, protection outside your home. Now, this case has made its way to the Supreme Court. Now, what I find interesting is that, to me, the heroine of this debate is sort of Amy Coney Barrett. And I want to tell you why. Because it's kind of funny, isn't it? You have this kind of mild-mannered woman from the Midwest, and she turns out to be the most full-throated defender of gun rights. But I think she's going to carry really all the conservatives, including John Roberts, with her on this. Now, initially, New York basically made the argument before the court, saying in effect that there's a lot of gun violence. We need to restrict guns because there's just a lot of gun violence going on out there. And New York invoked all kinds of scary specters. Do you want to have people carrying guns in a subway? They get into an argument, and gunfire breaks out? Justice Breyer, speaking for the left wing of the court, invoked the example of a law-abiding guy who takes his gun to a ball game. And then he gets a little drunk, and he gets into a fight over a call or over some other issue, and gunfire breaks out at the ball game? So this was the left basically making, you may say, prudential arguments for gun regulation. And interestingly, the conservatives on the court began to fight back with prudential arguments of their own. If you go to a restaurant and there's some crazy guy who begins to brandish a gun, wouldn't that person be deterred if there were law-abiding guys carrying guns who were there to stop him? Wouldn't that guy be less likely to want to open fire, knowing that there might be armed customers sitting in the restaurant? And of course, there were many familiar examples. Alito says, let's talk about somebody who cleans an office at night, or somebody who's a doorman in an apartment, or a nurse, or an orderly who washes dishes and is scared to death to go home. Basically, Alito says, wouldn't that person have every reason to want to have a gun? And why would you want to deny it to them, the right to defend themselves when the cops are not on the scene? New York tried to draw a distinction between, urban areas, which are different than rural areas. And Justice Roberts came back and said, no, listen, it's urban areas where you have things like muggings. It's urban areas where you get dragged into an alley. I'm not quoting Roberts. How many muggings take place in the forest? So the point here is that Roberts is basically saying that people across the country, not just in the countryside, but also in the cities, have a right to self-defense. But I think it was Amy Coney Barrett who sort of stole the show, because she zoomed into the core language of the law, which calls for special circumstances and, quote, good cause to carry a gun. So New York was basically saying, well, yeah, you do have the Second Amendment right to have a gun, but you need to show cause. And Amy Coney Barrett said, wait a minute. with what rights, with which of our other rights do we have to sort of show cause or make a special case that we should be able to exercise them? I have a First Amendment right to speak. Do I have to show cause for why I can speak? No. I have a right to free assembly. Do I have to show cause for why me and my friends are meeting at a certain place or time? No. So the point here is that the presumption is in favor of the right. You don't have to show cause. In fact, it's the opposite. New York needs to show cause for why they want to abridge a fundamental constitutional right. Let's remember that just because the Second Amendment is second, and let's say religious freedom is first or free speech is first, it doesn't mean that the Second Amendment is less important than the First Amendment. It's just as important. I think here the court was, on the balance, very skeptical of New York's attempt. And the beauty of them is that they strike down the New York law, they'll be striking down the California law and the Rhode Island law and the Maine law. So there will be a collapse of left-wing attempts to essentially push away the gun right, the Second Amendment right. We need a resounding affirmation of this neglected right, and it looks like the Supreme Court right now are the ones to do it.